Hello and welcome to the Minimum Competence episode for Monday, January 6, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, we cover the Supreme Court's role in Trump's policies, Biden's offshore drilling ban, TikTok's legal fight, and venue sports antitrust battle. Let's remember, the woods are lovely, dark and deep, but I have promises to keep, and read today's legal news. On this day in legal history, January 6, 1649, the English Parliament took a momentous step by voting to place King Charles I on trial for high treason. This decision came in the wake of the English Civil War, a prolonged conflict between Royalists, loyal to the king, and Parliamentarians seeking to limit monarchical power. Leading up to the trial, the New Model Army under Oliver Cromwell orchestrated Pride's Purge, expelling members of Parliament likely to oppose the trial. The remaining assembly, known as the Rump Parliament, convened and authorized the creation of the High Court of Justice, an unprecedented legal body tasked with trying a sitting monarch. The trial marked a dramatic shift in the balance of power, challenging the divine right of kings, a cornerstone of monarchical rule. Charles I was accused of subverting the laws of England and waging war against his own people, charges that he denied, arguing that no court held legitimate authority to judge a king. Despite his defense, the court convicted Charles on January 27, 1649, sentencing him to death. His execution on January 30th sent shockwaves throughout Europe, signaling the emergence of parliamentary sovereignty and temporarily abolishing the monarchy in favor of the Commonwealth under Cromwell. This legal milestone not only altered the trajectory of English governance, but also set a precedent for holding leaders accountable to the rule of law. The Supreme Court is expected to play a critical role in assessing the legality of anticipated Trump administration policies, particularly in immigration and administrative law. Immigration policies, such as ending birthright citizenship and mass deportations, are likely to be challenged in court, with outcomes depending on their framing, especially if tied to national security concerns, which the court tends to view more favorably than economic justifications. The court's recent decision in Loper Bright Enterprises v. Raimondo, which limited agency power by ending so-called Chevron deference, which we also have an episode on if you're interested in, may have far-reaching implications for both the Biden and Trump administrations. While reducing agencies' regulatory authority aligns with Trump's deregulatory goals, it also empowers blue states and civil rights groups to challenge his policies under stricter judicial scrutiny. Challenges to agency head tenure protections and interpretations of outdated laws could also come before the court. Trump's potential push to dismantle long-standing precedents like Humphrey's Executive v. United States could make federal agencies more directly accountable to the presidency, further politicizing their functions. Critics note that these shifts in judicial doctrine cut both ways, curbing regulatory power broadly, regardless of the administration in power. This duality underscores a tension between conservative goals of limiting administrative overreach and the desire to expedite executive policymaking. President Joe Biden is permanently barred offshore oil and gas drilling across over 625 million acres of U.S. coastal waters, including the east and west coast, parts of the Gulf of Mexico, and sections of the northern Bering Sea. Citing environmental risks and minimal energy gains, Biden stated the move balances conservation and energy security, ensuring that protecting coastlines and maintaining low energy prices are not mutually exclusive. The decision does not affect existing offshore leases or ongoing drilling in Alaska's Cook Inlet and the central and western Gulf of Mexico, which account for a significant portion of U.S. energy production. Biden's action builds on temporary protections enacted by former President Trump for Florida's Gulf Coast and southeastern waters, but makes them indefinite. While praised by environmental advocates and coastal communities, the oil industry criticized the move, arguing that it restricts domestic energy production and undermines national security. Some politicians from both parties have supported these protections, emphasizing the risks demonstrated by disasters like the 2010 Deepwater Horizon spill. Although Biden's decision relies on a federal law provision that may be difficult to reverse, legal challenges could arise if a future administration attempts to undo the protections. The debate underscores tensions between environmental stewardship and energy independence. The U.S. Department of Justice has urged the Supreme Court to deny President-elect Donald Trump's request to delay a law requiring TikTok's Chinese owner, ByteDance, to sell its U.S. assets by January 19th or face a nationwide ban. Trump argued for more time after his inauguration to seek a political resolution, while the DOJ countered that ByteDance has not demonstrated it is likely to succeed on the merits of its case. The government emphasized the national security risks of TikTok's data collection on 170 million American users, framing it as a tool for potential espionage. TikTok, however, has requested the court to block the law on First Amendment grounds, claiming it is being unfairly targeted for its content rather than its data practices, especially given Congress's lack of action against other Chinese-owned apps like Shine and Temu. If the law takes effect, new downloads of TikTok will be prohibited and existing services will degrade over time as companies are barred from providing support. The Biden administration could extend the compliance deadline by 90 days if ByteDance shows significant progress towards divestment. This marks a shift in Trump's stance from 2020 when he sought to ban TikTok over similar concerns. The Supreme Court is set to hear arguments on January 10th. Disney, Fox, and Warner Brothers Discovery are appealing a court ruling that blocked the launch of their joint streaming service, Venue Sports, arguing it unfairly restricts competition and consumer choice. The district court previously halted Venue's debut after rival Fubo TV sued, claiming the service violated antitrust laws by bundling sports content in a way that would harm competition and raise prices. The district court sided with Fubo, finding that the bundling practices could foreclose other sports-focused services and granted an injunction against Venue's launch. The media companies argue that the ruling denies consumers a lower-cost streaming option aimed at price-sensitive sports fans and protects Fubo from competition. They assert that Venue would increase consumer choice and lower prices. However, the Justice Department and several states have supported the injunction, stating that Venue's creation would consolidate market power among the companies, who control over half of U.S. sports rights, and hinder the emergence of competing sports-only platforms like Fubo. At the heart of the dispute is whether the bundling practices by Disney, Fox, and Warner Brothers unfairly disadvantage distributors by tying access to desirable sports content with less popular programming. The appeals court will now decide if the injunction stands. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than minimum competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, the best way out is always through.